Welcome to today's episode of LAWBY podcast. The topic for the day is usual bank drama of unilaterally appointing arbitrators for solving disputes in relation to loan agreements. An arbitrator is a person who is neutral and impartial in nature and whose role is to hear and make final binding decisions based on evidence for disputes that arise between the parties. An arbitration clause in an agreement consists of parties who in common agree in writing to solve the dispute that arises out of a contract without the intervention of a court but by appointing neutral arbitrators with the consent of both the parties. Appointment of a single arbitrator by one party alone without taking the consent of other party to a dispute, then appointed sole arbitrator is said to be appointed unilaterally, which is against the principles of arbitration. Unilateral appointment of arbitrators are common in standard forms of contract. In such cases, the other party does not have any negotiating power with respect to the alteration of the terms of an agreement. For instance, loan agreements, insurance agreements, and agreements for providing services are all drafted by the companies. Usually, the terms are non-negotiable by the other party. These are also called standard forms of contracts. Therefore, when a dispute arises between the parties, the dominating party usually proposes to appoint the arbitrator without seeking the consent of the opposite party. This is called unilateral appointment of arbitrators. Banks and financial institutions have a fashion of appointing unilateral arbitrators without the consent of borrowers, and as a matter of fact, they also include the appointment of sole arbitrator by lenders or lending agencies in their loan agreements. We don't generally read every clause of agreements, especially when we are in need of money, and the agreement is provided by the banks and any other trusted institutions. But in case of any default in repayment, we receive a notice from the bank stating dispute resolution mechanism, that is arbitration, initiated by the bank by appointing sole arbitrator without the consent of borrowers, and through which recovery of property as a only and final recourse for the banks. Can one party appoint arbitrator without the consent of other party in solving the dispute? Let us learn what the legal statutory provisions and courts of India say regarding this issue. Arbitration and Conciliation Act 1996 deals about arbitration and conciliation procedures in India. According to Section 11, Subclause 2 of the Arbitration and Conciliation Act 1996, the parties to a dispute are free to agree on a procedure for appointing the arbitrator. And Section 12, Subclause 3 of the Act allows for challenging the appointment of arbitrators if there were any justifiable doubts regarding the arbitrator's independency, impartiality, and/or he did not meet the prescribed qualifications as agreed to by between the parties. Also, Section 18 of the Act provides for equal treatment of parties, that is, the parties should be treated with equality and each party should be given an full opportunity to present his case. Here are some cases that would help you overcome unfair treatments by challenging the award passed by sole arbitrator unilaterally appointed by one party and the award is passed solely biased before the High Court. For an additional law tip, the award here refers to final binding decisions passed by the arbitrator. Moving on to the cases. In the case of TRF Limited vs. Energo Engineering Projects Limited, the court held that once the arbitrator has become ineligible by operation of law, he cannot nominate another person as an arbitrator, and that arbitrator becomes ineligible as per prescription mentioned in Section 12, Subclause 5 of the Act. There is a possibility of biasness in both cases, irrespective of which category the case falls. Therefore, applying the said test, the court held that a party or an official or an authority having interest in a dispute is entitled to make an appointment of an arbitrator. The issue when such a person himself becomes ineligible to become an arbitrator as per the operation of law, whether such ineligible person can appoint any other person as an arbitrator, has been widely discussed. Again, In the famous landmark case of Perkins Eastman Architects TPC and another versus HSCC Limited, the Supreme Court confirmed that the party or authority having interest in a dispute is disentitled to make an appointment of an arbitrator. In this famous case, the court observed various factors relating to appointment of sole arbitrators unilaterally. The court viewed two categories. First one is sole arbitrator as a person having interest in a dispute, and the second one is appointment of another person as a sole arbitrator by a person who is having interest in a dispute. The court clearly described the reason as follows: that whatever the advantage a party may derive by nominating an arbitrator of its choice would get counterbalanced by equal power with the other party. But in case where only one party has a right to appoint a sole arbitrator, its choice will always have an element of exclusivity in determining or charting the course for dispute resolution. Naturally, the person who has an interest in the outcome or decision of a dispute must not have the power to appoint a sole arbitrator. Also, this has been taken as an essence of an amendment brought in by the Arbitration and Conciliation Amendment Act 2015. Now, moving on to the legality of the award passed by the unilaterally appointed arbitrator and when the award can be challenged before the court. In the case of Cholamandalam Investment and Finance Company Limited versus Amarapalli Enterprises and another, the Calcutta High Court declared that award passed by the sole arbitrator as null and void ab initio, as it was nuanced in law and against the principles of natural justice. When dealing with the application filed under Section 36 of an Arbitration Act, seeking the execution of an arbitral award which is rendered by a unilaterally appointed sole arbitrator. The High Court, upon placing reliance on a catena of judgments, held that unilateral appointment of arbitrator, especially in absence of an express waiver in writing as contemplated under the proviso to Section 12 subclause 5, is void ab initio, and anything that emerges out of such appointment is also nuanced in law. Basically, it means it is against the law. The court also observed that awards passed by such arbitrators and its proceedings cannot be validated at any stage, even at the stage of execution, and thus the arbitral award so passed does not vary the fortune of legitimate existence. The arbitral proceedings conducted by a unilaterally appointed arbitrators carry a permanent mark of bias and ineligibility, and the same cannot be washed away at any juncture, including execution. Now, let us see what the Section 12 subclause 5 deals with. This section forbids the appointment of arbitrators having interest in the subject matter or any person whose relationship with the parties or counsel or the subject matter of the dispute falls under the category specified under the 7th schedule shall be ineligible to be appointed as an arbitrator. The 7th schedule of the Act lists various prior relationship of the counsels and the parties to a dispute. Also, a party cannot insist on the appointment of an arbitrator in terms of the agreement when the appointment itself is hit by the statutory bar under Section 12 subclause 5 read with 7th schedule of the Act. Therefore, a party cannot appoint his or her relative as an arbitrator to the dispute. In the case of Naresh Kanayal Rajwani and others versus Kotak Mahindra Bank Limited and another, the court held that mere fact that the party has participated in an arbitral proceedings, the same will not disentitle the party to challenge the award on the ground of unilateral appointment of arbitrator. The court states as follows: the specific manner of waiving the applicability of Section 12 subclause 5 of the said Act is mandated in the proviso thereof, but such procedure was admittedly not followed in the present case, and therefore it cannot be said that merely because the petitioner participated in the arbitration proceedings, they were disentitled from raising the ground about the arbitration proceedings having been vitiated due to unilateral appointment of arbitrator by the respondent bank. Accordingly, on this ground, the court set aside the arbitral award. In Geeta Podar vs. Satya Developers Private Limited arbitration, the court held that unilateral appointment of second arbitrator by the respondent is nuanced and the award is liable to be set aside. The court further held that even if the petitioner did not challenge the unilateral appointment under Section 14 of the Arbitration and Conciliation Act 1996, the right to approach the court for independent appointment is not curtailed. The court stated as follows: it is a well settled principle of law that arbitral awards which violate the fundamental policy of Indian law or the most basic notion of morality or justice are patently illegal and contrary to the canons of public policy. Accordingly, the award can be put to challenge under Section 34, Subclause 2 of the Arbitration Act. Hence, the unilateral appointment of arbitrator by a single party to a dispute can be challenged at any stage of the dispute, irrespective of the award passed or not. In spite of all these legal provisions ensuring the neutral appointment of arbitrators, the menace of appointing arbitrators unilaterally and initiating the process of recovery without the consent of parties is still in progress. That's it for the day. Thank you for listening to us. Subscribe and support us. Stay tuned, stay lobbyfied.